Para. The common ground for all the assessment years under appeal and in the appeals filed by the SEC for the assessment years 1978-79 and 1979-80 relates to the disallowance of various amounts under the head Sales Promotion Expenditure. The SEC is a private limited company engaged in the business of chemicals and dyes. For the various years under appeal, the SEC claimed certain items of expenditure described as sales promotion expenses. It was stated that the expenditure was incurred for the purpose of making payments to the employees of the various mill companies to whom goods were sold. According to the SEC, when chemicals and dyes had to be sold to the mills, this had to be accepted and their quality and acceptability was certified by dyeing masters and other technical people at various stages. It was not possible for the SEC to push the sales with these companies or having made the sales hope for further sales to them unless the officials of the mills at crucial stages of accepting the stores are kept in good humor. These persons had to be paid regularly certain amounts based on the extent of purchases of these commodities made by the mills and which, in their capacity as technical men, these employees certify for acceptance. The expenditure was clearly incurred for the business. If the persons who make the decision to purchase or certify the quality are not paid these amounts called commission, the SEC's business would have suffered and even may have closed down. From the very nature of things, the SEC could not give the names of the persons to whom these commissions were paid. Disclosure of the names would have created problems for these persons with their employers, and the SEC's sales to these mill companies would have been affected. The SEC therefore claimed before the ITO that even though full particulars such as names and addresses of the persons to whom the amounts were paid were not furnished, para. The learned counsel for the department has pointed out that in this case the SEC has claimed an expenditure as having been incurred wholly and exclusively for the purposes of the business. In that case, it was his responsibility to show that the expenditure has been incurred and properly incurred also. The SEC had claimed that certain amounts were paid to certain employees of the mill companies with whom it had business deals. The names and addresses of the employees have not been given, whatever be the purpose for which the SEC withheld the names for the purpose of income tax. Unless the payment is approved, allowance cannot be granted. It is only after finding out who received the payment. According to the learned counsel, it is possible to find out whether the expenditure has been incurred wholly and exclusively for the purposes of the business. Since the SEC has refused to divulge the names of the persons to whom allegedly the payments were made, according to the learned counsel, it was not possible to hold that this expenditure was incurred for the purpose of business and allow the payment. Taking us through the several orders of the tribunal, the learned counsel pointed out that in the earlier years, the SEC had absolutely no details regarding the payment and the claim was disallowed, even though for some of the subsequent years, evidences in the shapes of registers and details were sought to be produced before the tribunal, and the tribunal admitted the same. Such evidences on scrutiny also do not disclose the names of the persons to whom the payments were made. All the records produced in this connection relate to the employees or other persons connected with the SEC only. Their evidence cannot, according to the learned counsel, be taken as supporting the claim of the payment. Stop.